Welcome to part 3 of the AFJ Law Group's Small Business Bootcamp, talking about commonly filed lawsuits against small business owners and how to prevent them. This is the final segment of our series, and we have two heavy hitters to talk about today: tort claims and breach of contract disputes. So let's dive right into it.
Make sure you like and subscribe to our YouTube channel.
I'm attorney Alexis Johnson of the AFJ Law Group PLLC. And if you're just tuning in, this is part 3 of our 3-part Small Business Bootcamp. As I said in the beginning, this bootcamp focuses on commonly filed lawsuits against small businesses. So I'd encourage you to check out the other videos on our channel talking about the first 3 categories. But let's go into all 5 categories and then really hone in on the last 2 in today's video.
The top 5 most commonly filed lawsuits against small business owners are discrimination against workers, discrimination against customers, wage loss claims, tort claims, and breach of contract disputes.
You check out the other videos on our channel talking about the first 3 categories of lawsuits, but today's video will focus on the last 2, tort claims and breach of contract disputes. And I will tell you from experience, these claims are extremely common, and the likelihood of your business being in a lawsuit alleging this type of claim is high. So let's get right into it. What's a tort claim? Well, fortunately, a tort is not a delicious sounding dessert like you might hope. A tort is an act or omission that gives rise to an injury or harm to another, which amounts to some sort of civil wrong and where courts can impose liability. There's 2 types of torts: intentional and unintentional. So let's dive a little bit deeper so that we can distinguish these categories and so you know, as a business owner, what to look out for.
Now, when discussing tort claims, it's important to note that there are a lot of different types of claims that can be made under these 2 general categories. So this is a brief overview. But when it comes to intentional tort, the focus is on the intent. So the person who allegedly committed a tort must either intend the consequences of their actions or know with substantial certainty that certain consequences would result. There must also be some sort of injury or harm suffered from the person who is seeking damages. Common examples of intentional torts are assault, battery, defamation, and these are claims that you may have heard of from friends, relatives, or even reading the news, but you may have never considered how they could impact your business.
Unintentional tort, also known as a negligence claim, is different from intentional tort because there is a lack of intent to cause harm. However, this means the definition of negligence is very broad. Negligence is about breaching the duty we owe others. This duty is determined by Michigan law. To prove negligence, there must be a showing that the business owed a duty that was breached and the conduct created by the breach caused legally recognizable injuries. Another way to look at duty is to consider whether the risk of harm is foreseeable or predictable. Common examples of negligence claims are slip and falls in retail or grocery stores due to wet surfaces from cleaning, or hot coffee spills due to lack of warning on packaging. A negligence claim is very fact-specific, and there are many elements a court considers before first determining what type of duty a business owed to a patron or customer. So it's important to work with counsel to evaluate your business's exposure to liability. So how can you protect your business? Here are some general tips that can help avoid all kinds of tort claims. First, create best practices that include the standard of care for a reasonably prudent person in your industry. Best practices help ensure that you are taking the expected safety precautions of a similarly situated type of business. Another helpful tip is to create waivers or release agreements for customers to sign depending on your industry. These agreements are more enforceable in court than most people think they are. However, it's important to keep in mind that a waiver or release agreement will not protect you from third-party claims. Although insurance can protect a business in a lot of ways, it does not protect in all ways. While some claims may be covered under a general liability policy or a personal and advertising liability coverage policy, it's important to verify the type of coverage and protections provided under your policy. Finally, working with a business attorney to evaluate the entity structure for your business will help you understand what type of liability your business is exposed to. And if you're a new business or considering starting a business, entity structure information is extremely important, and you should spend time considering what type of business you want to create, future goals for the business, and what structure makes the most sense. It's always a good idea to have your insurance coverage, agreements, and business practices reviewed by a business attorney to reduce liability claims before they start. Now, while it may seem like a tort claim is similar to a breach of contract claim, they're actually very different because tort claims are not based on any sort of contractual right. That's why there are contractual disputes. So when someone is asserting a breach of contract claim, they're basically saying that there was a failure to comply with some or all of the terms of a contract. And this is really common in the business world, especially between other businesses. This type of claim can take shape in many forms because it's based on the terms of each contract. So it could be something as simple as goods weren't delivered, or the goods that were delivered were defective, or they weren't paid for. And it could be even more complex, like revealing trade secrets. This is why courts will take such a case-by-case inquiry because it's really dependent on the facts and the contractual language. Because contracts require certain provisions in order to be legally enforceable, we recommend working with counsel when preparing them. However, here are a few general tips to protect your business. First, don't fall into the template trap. Templates have no place in your business when it comes to contracts. While templates may be tempting, they are often too generic and overlook specific provisions that may affect the enforceability of your contract. Next, it's important to review any prior agreements to make sure that they reflect changes in Michigan law as necessary. And finally, get all amendments in writing unless another agreement was made. As a small business owner, you have a million things on your mind at any given moment. We know that, and we understand that at the AFJ Law Group. And that's why we created this Small Business Bootcamp to provide a snapshot of the top 5 most commonly filed lawsuits against business owners and some practical tips on how you can work to prevent them. But don't feel like you have to navigate this alone. If you have questions, please feel free to reach out to our office. We can be reached at afjlawgroup.com, or you can text or call us at 248-266-2135. Also, please like and subscribe to our YouTube channel so that you can continue to receive informative legal videos like this one. Thank you for checking out this video.